Number 17, People v. Hartle.
Good afternoon, Your Honor. May it please the Court, John Sarando from Syracuse on behalf of the appellant, and I would request 2 minutes for rebuttal if necessary.
You have 2 minutes, Mr. Sarando.
Thank you. This is an appeal from a memorandum in order of the Third Department affirming the denial of our client's CPL Article 440 motion. There's 2 issues that I'd like to discuss this afternoon. Briefly, the denial of meaningful assistance of counsel. Sort of a unique situation here. This district attorney was being investigated and retained an attorney to represent her during the course of the investigation. The services terminated prior to my client's retaining of this attorney. However, when he was arraigned, everybody in the courtroom knew that the defense attorney had represented the DA, except my client. The Third Department indicated in a footnote in the decision that he should have been informed of the essence, informed of this relationship.
How did that conflict, as you suggest, operate on the defense here?
It operated on the defense because, Your Honor, the essence of the attorney-client relationship is the trust and confidence that the client has in me as their attorney. And my client indicated that he would not have retained this attorney if he knew the attorney had represented the district attorney, and if he learned of it during the course of the proceedings, he would have fired him. So I think it goes beyond the trial. It goes into the obvious that
That goes to what, assuming and accepting the statements as true, I'm not challenging them otherwise, that only goes to the client's preference. Right? If I had known this wouldn't be the representative I would have chosen, right? But how does it address Judge Troutman's question about the impact on the defense itself? I mean, one could want a different lawyer, even if you've got a great lawyer who would do a
Very good
spectacular
lawyer.
defense for you,
Very
maybe
good
did.
It operates on a defense because the relationship between Ross, the attorney, and the DA, we submit impacts on the trial strategy of the DA, of the defense attorney, so that he doesn't stream into the same area.
You're saying he's not going to be as aggressive in
Yes.
challenging things the DA is doing and so on because that's his former client?
Right at the start of trial, I think it came about where there was a 4-page report given, and then it becomes a 5-page report. The DA was blaming it on the state police investigator. And the judge gave the choice of either having a mistrial because she did something wrong, which was declined. And they ended up with I'd say a milquetoast charge for failing to do the blanket. But
Could I move you to the other issue so
Yes.
you don't run out of time? I'm sorry.
yes. The other issue is newly discovered evidence. There were text messages and telephone call and photographs between the defendant and JB. These were deleted by the defendant before his arrest.
Well, were some deleted automatically by
Yes.
the software?
Yes,
Were some deleted deliberately by him before his arrest?
yes.
Were any deleted by him deliberately before his arrest but knowing that he was going to be arrested?
No.
My understanding is that in the 440, the court ordered the production by the people of JB's phone, and that didn't happen, and what you were trying to do was to see whether the people all this time had in their possession either some of the texts that you were ultimately able to recover from the defendant's phone, whether those had been deleted either by her or automatically or whatever, and whether, because the relatively short period of time that the people had produced what they had taken from JB's phone didn't match up with the period of time. Well, there are two things. There was some overlap, and you were able to recover things ultimately from the defendant's phone that were within the time period that the people had searched, but were not what the people had produced to you.
Right.
And there were also other texts from a different period of time that you don't know whether they were on JB's phone or recoverable from JB's phone.
Correct. Yes, Your Honor.
So that's sort of the lay of the land.
Yes, and with one caveat.
Yep.
On the chart in our brief, there's an August 14 picture that was sent by JB to the defendant. It was recovered. The state police did an examination that from June to September. Curiously enough, that photograph was not, I don't think, recovered by the state police.
Is that a Snapchat screenshot? Is that the one you're talking about?
Some of those are snapshots, yes.
So, as I understand what you offered was material recovered from the defendant's phone.
Yes.
That's it, right? You didn't go to Snapchat to see if they had anything, right?
No, it was everything out of the defendant's phone.
So the newly discovered evidence you've offered at the trial level for 40 court was only material you recovered from the defendant's phone.
Yes, yes. And curiously, when we started, and we were first in the court, the trial court indicated to the district attorney, I think it's 456, 459, 460, go check with her and see what's going on, get her phone and see what's up with her phone. They never did that.
I have 454 to 455. I will direct them to inquire about the alleged victim's phone and have that sent to their expert and provide that to you so your expert can look at it, and that way everybody gets a fair shot at what's going on here.
That didn't happen.
That's the way I read the record. It didn't happen.
No, no.
But the defendant knew about the texts and the photographs and chose not to cross-examine the victim about that. It wasn't for lack of having the evidence, it was a trial strategy, that the trial strategy was, it never happened.
I think you have to go back. You have to go back to the start of the trial, Your Honor. The start of the trial, before there was talk about a plea bargain, the mother insisted that there'd be forcible compulsion, okay? The mother insisted that any plea had to be forcible compulsion to protect her daughter's reputation. And counsel, I think, indicated that no good attorney would ask a question without knowing the answer, especially on cross-examination of the JB if they didn't have specific evidence in front of them that this is what she had said.
But they knew the evidence. His position was there wasn't forcible compulsion. So I
No,
guess
his
I'm having
position was
trouble
there was
wrapping my
nothing-
head around a trial strategy where a defendant makes a deliberate decision to delete evidence which goes against his position that this never happened, and then when that fails, now saying, you know what, if I had had these pictures, I could have pursued a defense of no forcible compulsion, when really the fact that you didn't have the photographs didn't preclude that defense.
As Judge Richards said, the possession of this information would have made trial strategy completely different, and it would have been a different trial. And
I agree with you, Mr. Sarando. I guess I'm having difficulty because the defendant made the conscious decision to delete it.
before he was arrested, the victim also made the conscious decision to delete it from her phone too. He deletes it so he looks good, she deletes it so he looks worse.
But
Or
he
maybe because
never-
she's a child.
But I don't see anything in the record that there was any effort made at that time. And I understand the position later that we couldn't have done it, but there's no record evidence that it was attempted.
It wasn't attempted, but I don't mean to be impolite, but if you couldn't do it in 17,
Well, they couldn't do it through the one method that you have an affidavit for, but there was never any attempt at that time to do it. So we don't know if there were other methods at that time, if it was possible. And to Judge Singus's point, I believe there's a plea offer on the record without any issue of consent that the court approved for 5 years. These photos, in a way, convict on one count, right? Because you can't argue it never happened anymore, and she's underage. So how is that not a trial strategy, especially when you reject a plea that was essentially the equivalent of that count?
it's not a trial strategy because, number one, you don't have the evidence. You don't
You
have
never
the
asked
evidence.
for it. You never tried to get it, and you knew it was there.
Well, but the
Are you
technology.
suggesting
the-
that it was generally known what was on there and not specifically, so that impacted counsel's decision-making?
I think all of this, I think, is something that you would ask counsel at a hearing. The
Did you-
first
did
step
you
in our roadmap is we want a hearing.
And you asked for a hearing below on
Yes.
this, correct? And didn't
Yes.
get one?
Right. I think a lot of the things that the court is pointing out are things that would be answered at a hearing.
Would you agree that it would make a difference to your argument if we knew that the defendant had deliberately deleted the emails, texts, I guess, knowing that he was about to be arrested or indicted, or whether his software was set up so that text messages were deleted automatically after 30 days? Would that make a difference to your argument?
I think the bad part for our argument would be if he was under the impression that he was being investigated for something, which that is not in the record. So we would submit that that did not take place.
Thank you, Mr. Sarando.
Thank you, Your Honor. Oh, hopefully, one thing, Your Honor. Hopefully, the respondent will indicate why they didn't follow the judge's directions as far as the phone and speaking to the victim.
Let's see.
May it please the court, Matthew L. Peabody, Assistant District Attorney, St. Lawrence County, on behalf of the respondent. I'm going to very quickly just address the ineffective assistance through the operation of a conflict of interest real quickly, because it seems that the focus in this issue is on the newly discovered evidence. But with respect to the conflict of interest, I think that what appellant is urging is for this court to adopt a new standard that would state that defense counsel has a duty to advise the clients of every potential conflict that could possibly exist, whether or not that has any effect on the defense at all. And that's clearly, I don't think, a standard that we can adopt here. I think if you look at the conflict of interest, and there's no dispute by the parties or anyone that it was a potential conflict of interest at the time of this defendant's trial, the standard requires that he show that it had an operation on the defense. And he wants to kind of skirt around that and say, well, it would have affected my decision to hire this attorney in the first place.
About the argument that it did impact on the trial because, and defense counsel's conduct, because defense counsel basically pulled punches or made decisions that were not solely focused on his client at the time, but on the possible impact on his prior client, or at least the prior representation.
I think that argument's completely unsupported by the record. I think if you want to delve into that and actually look at the record in terms of what evidence is there that this conflict had no operation on the defense, I think there's plenty of examples contained in the record that we have here, although we don't have, for the record supplied to you, we haven't included the full trial transcripts. We have included the cross-examination of the pertinent parties, the main victim being the most important. I think a review of that cross-examination, which is on the records 391 to 435, shows that they did a successful job of impeaching her, drawing out concerns and issues with her testimony that would be ripe for a jury in terms of their credibility determination. Things like she didn't tell anyone because she was afraid they wouldn't believe her, but in fact there was proof that allegations of this nature had been raised in her family before and had been.
You had wanted to spend more time on the second issue, so maybe I'll scoot you over there.
Thank you, Your Honor. I'll move right over to there. So I think focusing on the newly discovered evidence issue at its principle, I think we have to look at the two places the court draws its rule of law from. We can either analyze it under CPL 44010, I think it's 1G, which gives some strict language about what new evidence is and why a defendant would be entitled to vacate a prior conviction, or at least to have a prior conviction reconsidered. And then we also have this court's six-factor test that was somewhat recently reconfirmed in Salimi. It's an older test. It's been in existence for over 100 years here in New York State.
So what's your position
Well, I
as
think-
to the evidence here?
Well, I think if you focus on both of those standards, they require in common, plain language that it be newly discovered.
At the 440, the ADA who appeared there said, I think our position is, yeah, it's newly discovered.
No, I
I'm
don't
reading-
believe that we've ever conceded that, Your
I'm
Honor.
reading you the transcript from 453 of the record. It says, he wants us to take a position as to whether or not this is legitimate newly discovered evidence. I think our position is, yeah, it's newly discovered. We're not taking issue with the fact that it wasn't previously available. The question now we have to evaluate it, and we just need a copy of it. That's right there.
Thank you, Judge. I apologize. With all due respect to Chief Haberkornholm, I disagree. I think a plain definition of the word discovered
Yeah,
implies
okay, but it's a
not having knowledge
little
of it.
difficult when you're in the court of instance on the 440 saying we agree this is newly discovered, then come up here and argue the opposite.
But it's outside of that transcript, Your Honor, the argument before the third department and the argument in the briefs here has been that this
Well,
isn't
you can
newly
argue things in front of
discovered.
the third department that aren't preserved, but that doesn't mean we can get to them.
But our position, at least my position, has always been that this isn't newly discovered, that word has a definition, a plain meaning. CPL 440 doesn't define it. Salimi doesn't define it. So then we're left with what is the plain definition of the word discovered? We can go back to law school and look at Black's Law Dictionary, which defines discovery as the act or process of finding or learning something that was previously unknown. We could go to Merriam-Webster's dictionary for a definition of the actual transitive verb discovered.
But looking at 440.10.1G, it says new evidence has been discovered, so I take your point about how to deal with the undefined nature of those terms. But then it says, which could not have been produced. So doesn't that seem to suggest that the point of discovery is whether or not you could have brought it forth to the court?
I think that's exactly right. And in this situation, we have two things to consider with respect to that. One, it couldn't have been produced because the defendant himself destroyed it. And
Well,
two, he
well-
doesn't show any
What about
diligence
the
in
stuff
trying
that's
to produce
automatically
it.
deleted? What about the stuff that's automatically deleted?
Well, I don't think there's any proof in the record that establishes that that's the case, but even so...
Well, let me ask you hypothetically.
Let's
Is the
assume-
rule you're looking for that even something that's automatically deleted?
No, I think, so let's assume that these things are automatically deleted. So at the time that he's developing his trial strategy with his attorneys, he's aware of the context, but no longer has ability to get it, well, then I think we're into the due diligence requirement. They do nothing to try to attempt to obtain this material. And I think that the report that we have now, I think it's important to draw a distinction and actually look at what the expert says in that report.
Yeah, but again, 440.10.1G, talking about due diligences, which could not have been produced by the defendant at the trial, even with due diligence. I'm
Right.
not sure what's the due diligence you're talking about, but even with. And so if the expert's affidavit is that I couldn't root, right, this material until I've got this update. Once I had the update, I was able to root it, I immediately turned it over to them.
But that's not what the expert's report
Okay.
says. I think if you read that, you'll see very clearly what he actually says is the Kingo root software that I used existed and was developed first in 2013. This trial happens later in 2016. And he says, he basically says that I used technology developed by KingoSoft in 2017. He doesn't say that the technology as it existed at the time of defendant's trial wouldn't have been able to
Yeah, but
do
he
this.
does clearly say that the reality is with these older Androids, technologies evolves over time, and that's what lets you access. I mean, take Mr. Sarando's point. If it's not accessible in 2017, the likelihood of it having been accessible years before is zero.
But we don't know that it wasn't accessible in 2017.
Well, why not have a hearing on that? I mean, it's possible to read the affidavit as I've suggested, so why not just have a hearing on that? Go ahead,
Well-
cross the expert, bring in your own expert.
Well, I think that on that issue, I don't think that would be determinative to the whole analysis, because
I do
even
wanna-
even if we could just say that he's excused from having to have exercised due diligence because it would have been impossible, we're still left with considering the other 5 factors of Salimi and what does newly discovered mean.
I do want to ask you about JB's phone and why it wasn't produced and why it shouldn't be produced and have a hearing to find out what's on it. It seems to me it could be quite relevant, right? For example, there's a period of time you did search and you didn't produce some of the stuff they were able to root from the defendant's phone that were texts back and forth between the two of them. So that means to me either it was not on JB's phone because I suppose it had been deleted, which then might bear on the question of, whether other things were intentionally or not intentionally deleted. It might be there and you might now be able to, root it, for lack of a better word. It wasn't, and that may bear on the question of whether it was technologically possible at the time to get that kind of information off of a phone. I don't know if her phone is the same type as his, so that's also another question. And then there's a long period of time, most of the texts that the defendant has identified that suggest perhaps a lack of forcible compulsion are from a period of time that the people didn't attempt to retrieve from the phone. And so that also seems like something you'd want to know as to whether that's there, whether that's deleted, whether those, it bears on what we're trying to figure out here.
I don't see how it bears on whether this is newly discovered evidence and meets the factors under Salimi, whether or not the evidence existed on the victim's phone. I think that what we have with respect to the victim's phone, and if you take it in the context of the report we now have on the defendant's, what we have with the victim's phone is it was analyzed by the state police. They did produce a forensic report, and they stated that the reason they didn't do the extraction that was done by the defendant's experts is it's not a process that they do. Rooting of a cell phone inevitably destroys that forever, and the state police forensics don't typically do analysis of evidence that's going to destroy that evidence.
Where is that in the record?
I don't believe that's in the record, Judge, because we haven't supplied our own expert opinion about this analysis. But that is my understanding of the rooting process and why the state police don't do it ever. The other thing, too, I think that's, to answer that question with respect to what we do have in the record before us, I think that that's so hypothetical that it doesn't factor in here, because if you look at even what was recovered from the defendant's phone, in there you can see gaps in the text messages that are unnatural. For example, if you look at the record on page 204, you'll see a conversation that kind of starts out of nowhere. You're following the text chronologically, and the defendant will say, "How was your day?" And then 2 hours later, he texts again, "What's that?" And she responds, "A singing kind of show." So in between there, you realize there's a conversation that took place, and it's not captured here for whatever reason. Even his routing of the phone, it's not like we're looking at a 100% complete picture of what's there. It's completely incomplete. And so to assume that doing this to the victim of a crime like this years after a conviction at trial and forcing her to now turn over this phone, we're going to root it, we're going to look in it again, and assuming that would produce, evidence showing that she had or had not deleted these.
Well, you were ordered to do it, right?
Yes, that is correct, Judge.
Thank you.
Thank you.
I'll be very brief, Your Honor. I think my opposing counsel has made a good argument for me as why there should be a hearing. And for the Judge Wilson's indication that there was the order to go to her and turn over the phone or get the phone, and when we were in court, the phone was in their case box of material. So they had the phone all along. They didn't tell Judge Richards until
And
the
counsel,
second time we came
counsel,
back.
what's your view of the relevance of the victim's phone?
The relevance of the victim's phone is to show that she deleted the messages so that he would look bad.
But how is that relevant to your newly discovered evidence motion?
Because the motion relates to the issue of, in part, forcible compulsion.
Right.
But I think,
Isn't that more of a prosecutorial misconduct case? One, if they didn't examine the phone properly, or if they didn't turn over material to you that they had, that's exculpatory. So what's the relevance of the victim's phone to your newly discovered evidence?
the relevance of the victim's phone would be to confirm the fact that, contrary to what they're saying, that they were saying then in county court that it was not legitimate. This shows a legitimacy to our evidence.
So authentication is what this is relevant to?
It's relevant to the whole motion.
But how? You're saying, I didn't have this evidence, I now have this evidence, it's on this phone, it shows X. Assume we accept that it shows X. What's the relevance of the victim's phone?
Thoroughness. There may be something more on her phone that wasn't.
It's a more newly discovered evidence.
It's more, yeah, it's more duly discovered. I think all of these problems or issues would be solved at a hearing.
But there is a threshold showing that needs to be made before you root a victim's phone and get a hearing, that somehow, one, this is newly discovered evidence in some way, and two, the relevance of what you want to do. And I'm still having some trouble understanding the relevance of the victim's phone.
The relevance, I think, would, if they were deleted on the phone and not just sloppily done, if they were specifically deleted, I think they would show the victim's position in the case. And it shows that her testimony was not true.
So why doesn't the deliberate deletion by the defendant play in the same way? Show that how can we claim now that it's newly discovered when he made a conscious decision to delete it? And he said it in an affidavit.
And so did
I believe he said, I did not want anyone to see them.
And so, but it was before he was, that was before he was arrested or being investigated for the matter. So
But he knew that he was an adult male having sexual relations with a child. So maybe he was deleting them because he didn't want his wife to see them. Maybe he was deleting them because he thought someone would take offense to that. I mean, there's any number of reasons why, but the
Also,
point
it's
is...
a crime.
It's criminal activity on his phone that he deleted, and now he comes to this court and says it's newly discovered.
Oh, it is, it definitely meets the Salimi standards. I mean, I think we've laid that out in our brief. And, it shows, she was trying to put her, it shows whether or not she was trying to put herself in a better light than she actually was in by deleting this material. And whether it comes out, when it comes out at a hearing, it may be prosecutorial misconduct. It may be a violation of Brady material. It may be...
Did you raise any of those issues below, Brady or prosecutorial misconduct?
That would go into a hearing.
No, you raised a newly discovered evidence motion.
Well, the newly discovered evidence is the rubric that allows you to utilize the telephone. I think the judge, didn't the judge indicate this may be, someplace Judge Richards indicated this may be Brady material. We've got to look at, see at what she had. I think the thing that shows the newly discovered and shows perhaps the district attorney's, the conduct stuff is that what was not recovered when they recovered. That August photograph was not recovered from her phone, but it was recovered from his phone, and it
Thank you,
came from her.
Thank you.
Thank you, Your Honor. Sorry I went so long.